for us to learn. So, Doug, if you're good, let's get started right away and be able to ask some questions. And
Right. Thanks a lot, Maria. Um, so for those of you who don't know me, my name is Douglas Elliott. I'm a partner in Cambridge LLP, based in Toronto. I'm the co-chair of our constitutional and human rights practice group. I've been involved in a number of significant constitutional challenges in the Supreme Court of Canada. Also had 40 years of experience in the AIDS movement in Canada. So I'm committed at a very deep personal and philosophical level to the concept of harm reduction, even though I'm not a vapor myself. So with that bit of back, and we've been working with the Canadian Vaping Association in fighting various efforts to try and exterminate this business and to take away this choice from Canadian consumers. And this is the latest salvo in this war. Um, as a lot of you will know, one of the challenges we've faced in this area over the years is this conflation of smoking tobacco with vaping, which is really scientifically without any merit. Really, the only thing that they have in common is that they're both nicotine delivery systems. Apart from that, the health impact is vastly different. Not only that, in fact, um, I think the evidence is pretty convincing that it's a very popular choice for harm reduction for adults who have a history of smoking, who either reduce the amount that they smoke or quit smoking altogether by taking up vaping, because nicotine is a very addictive substance, but it's not really very harmful on its own. What is harmful is combustible tobacco. And there's no combustion involved in vaping or tobacco. Uh, we know that was a history with the tobacco industry of lying about the health effects of tobacco. There's some famous, you may have seen some famous newsreels with the tobacco company executives showing up smoking cigarettes in front of Congress, telling them that smoking's great for you and there's no evidence that it's harmful. So there is a long, long history in the tobacco industry of misleading consumers. They used to hire doctors to promote smoking as good for your nerves, soothing to your throat, and so on. And um, that led to a campaign to not only restrict tobacco advertising, um, packaging, and other things, but also to try to recover the healthcare costs. In Canada, of course, we have socialized medicine. There was a lot of the provinces felt, because of the terrible health impacts of combustible tobacco, that there was a burden to the healthcare system, and that the fat profits that had been enjoyed by the tobacco companies over the years ought to be clawed back by the provincial governments in order to um, recover some of the expenses that they laid out for well-known diseases connected to combustible tobacco, such as heart disease and lung cancer. Uh, but there wasn't really in law any basis for the provincial governments to sue the tobacco companies. Sorry. So for those of you who didn't hear, I have COVID-19. So I'm afraid I will cough and I'll sound a little stuffy. Um, so what they did was they invented a legal basis for suing the tobacco companies to recover their healthcare costs. They passed laws that allowed the provinces to sue the tobacco companies to recover that money. And not only did they create a legal mechanism to recover those healthcare costs, but they stacked the deck, putting in special provisions that would make it faster, cheaper, and easier for provincial governments to recover that money. And that went to the Supreme Court of Canada in a case called, appropriately enough, British Columbia and Imperial Tobacco Limited, where all of the big tobacco companies challenged the constitutionality of this legislation. And they went down in flames. The Supreme Court of Canada said that this legislation was plainly constitutional in the context of big tobacco, and that even if the civil remedy system that set up was a little unusual and perhaps not as fair as the normal process, it still was was a process that would allow the tobacco companies to defend themselves, and so it wasn't completely unreasonable and or completely vague. And so they said it was okay to allow the provinces to proceed with these lawsuits, and they did. And there have been major settlements, including, I understand, a settlement with British Columbia that was worth $1 billion. It was really ruinous for the tobacco companies, which of course was a twofold aim. One was to recover those costs, a money grab, as Maria said, but the other part of it, of course, was to deprive the tobacco companies of their profits and hopefully drive them out of business. So all well and good as far as that goes. I personally don't have a lot of sympathy for the tobacco companies, but the people who are against vaping have long, as I said, conflated tobacco use. The big fight has been with vaping, which is completely inappropriate because vaping actually leads to a reduction in tobacco consumption. I think the evidence is pretty compelling on that front. But the anti-choice forces have never accepted that. It's like the old myth that, if you smoked a joint, that you were going to end up becoming a heroin user. That's kind of the myth that gets propagated out there. And there's also a belief that that it's a way, in particular, of getting young people hooked on nicotine and then get them into a lifetime of smoking tobacco. Of course, we have had the problem of some in the United States as sort of a shadow cast over Canada by the Juul experience, where there's no doubt that Juul engaged in some very bad behavior, and that's had knock-on effects for the industry here. And there's also a perception, I think, by many people in public health and the anti-choice brigade that the vaping industry is just I'm sorry, I seem to have lost my light a little bit here. That this vaping industry is really just a stooge or a stalking horse for big tobacco, which certainly hasn't been my experience in the time that I've been involved in supporting your association. So they have now brought in this bill, which is virtually identical. It has some differences, but this bill, with the proposed Vaping Product Damages and Healthcare Costs Recovery Act, which is intended to follow in the footsteps of the tobacco legislation. And it has been promoted by the British Columbia government by claiming that the vaping industry engages in deceptive practices and that consumers are being lured into vaping through misrepresentations, and that's causing healthcare harm, and that healthcare harm is imposing a financial burden on the British Columbia government, and the British Columbia government is determined to recover money from the vaping industry, just like it did with big tobacco. And let me be clear, if you read the bill, vaping industry is very broadly defined. It's like anyone who's had anything to do with vaping, including consultants who are people who advise vaping people in the vaping field. So I suppose theoretically the government of British Columbia could sue me for for appearing on this webinar because I'm advising you about their bill. It's extremely, the targets that are named in the bill are very, very broad. It's not anything like big tobacco companies. It's anyone who's got anything to do with vaping. Uh, so it's very, very broad. I know that Sam Tam and the people at the Canadian Vaping Association have been lobbying the British Columbia government about this bill. Um, I I certainly agree with Maria that I think this is a money grab, but I think it's a lot more dangerous than that. I think that this could be this is the latest technique that the anti-choice crowd has come up with to try and do indirectly what they cannot do directly. What they would like to do directly is they would like the federal government to ban vaping in Canada. That's what they'd really like. But the federal government has refused to do that. And in fact, I think Sam and his team have done a really excellent job at the federal level, convincing the federal government that, as in the United Kingdom, that vaping is a good option for people who want to reduce the harm caused by combustible tobacco. That they seem now to be accepting that is okay as a choice for adult consumers. So having failed at the federal level, the anti-choice brigade is busy at the provincial level trying to come up with, you see, the provinces don't have the constitutional power to ban vaping. That would be a clear intrusion on the federal government's power, criminal law power. Only the federal government can outlaw an activity. So the provinces have to go chew around the edges of it and do things that have the effect of outlawing the activity without actually outlawing it, because if they actually outlaw it, then they are acting unconstitutionally. So I think that this bill is extremely dangerous. It's way more dangerous than the flavor ban, in my opinion. Because it apes the tobacco legislation, which has already been upheld by the Supreme Court of Canada and used effectively by the province of British Columbia. I think it's super important that people who care about vaping as a choice heavily lobby the British Columbia government and try and stop this legislation or see that it gets amended significantly. The same logic just doesn't apply. And I think there's some constitutional vulnerability in this circumstance because it's different from tobacco. In the tobacco situation, as I said, there was clear evidence of a history of deception. There isn't such a history here. Secondly, in the tobacco case, both the province and the federal government wanted to curb smoking, and so they both had the same objectives, and so the province was not undermining federal policy. In this case, I think we have an argument to make that the province of British Columbia is undermining the federal government's strategy. In fact, I think there's an argument to be made that you folks are actually saving the taxpayers of British Columbia money, because there's lots of people who aren't smoking and aren't putting a burden on the healthcare system because they're vaping. The burden on the healthcare system in British Columbia from vaping is trivial, if non-existent. And it is actually getting people off combustible tobacco, which clearly does put a financial burden. I do want to say that if we can't get this thing amended or stopped, I will certainly be talking to the CVA about the possibility of a constitutional challenge to the legislation, Although I have to be very clear with you folks that that's going to be an uphill battle given the precedent from the Supreme Court of Canada in the Imperial Tobacco case. Um, the other thing, though, I want to say is that um, the legislation does not impose a financial penalty or burden on the vaping industry immediately. What it does is it lays the groundwork for lawsuits against the industry that the government of British Columbia would then have to bring. I think that those lawsuits can be successfully defended because the whole premise of it is that the government of British Columbia stands in the shoes of a consumer, and they have to establish that the person who's being sued harmed consumers in some way, that they did committed a vaping wrong, as it's described here. So they have to show that there was some kind of misrepresentation, or they were sold something was adulterated, whatever. Of course, we know that does happen in the black market, but in the regulated market, that's just a nonsense. I mean, you folks, the industry is highly regulated in terms of packaging and advertising and so on. So as long as you're following all the rules, it's hard to see how you could possibly be said to have misrepresented anything to consumers. And if the government can't establish that, then they still lose. But dealing with those lawsuits is going to cost a ton of money. There's no doubt about it. And that's one of the things that they're trying to do. It's basically to scare you into shutting down. And as I say, that's having the vaping industry shut down is what the anti-choice brigade is all about. It's a stupid objective, in my opinion, because we know that if they were successful and the legitimate vaping industry was shut down in this country, the result would be a lot more people smoking combustible tobacco and a thriving illegal vaping industry that they would never be able to effectively police. You just have to look at the experience of prohibition in this country in the 1920s when they tried to outlaw alcohol for adults. It just led to organized crime and terrible social problems, far worse than the social problems caused by alcohol consumption. Because when adults want to use a product, they will find a way of getting access to it. So for a safe and effective product like this, really the only sensible choice is to sell it legitimately and in a regulated way to make sure that it doesn't fall into the hands of children, if possible. You'll never have a system that it's 100% foolproof. You see in the background the beautiful scenery in my hometown of Elliott Lake, and I can tell you when I was growing up, it was illegal to sell alcohol to people under the legal drinking age, but we certainly found a way to get access to it. And that's always going to happen. And just because that always happens doesn't mean that the product should be outlawed for adults. So that's my 20,000 foot overview. I wish I had happier news for you folks about this bill, but it is a clear and present danger to vaping, not just in British Columbia, but I think if British Columbia is successful, then the anti-choice forces are going to be trying to roll this out across the country.
Great. Thank you, Doug. We have a couple of questions. How are you feeling first?
I'll hang in as long as I can, Maria, but
Okay, you just
I'm not fabulous. I have to be honest with you.
yeah, your sparkle's not there today.
Yeah.
I love your sparkle. Uh,
Thank you.
so we have a couple of questions. I have some questions to ask if you don't mind, because there are a couple of law firms, specifically when I dug a little deeper, law firms that kind of defended tobacco in these lawsuits that have kind of done an analysis and what some of the things that like really concern me. One is that I'm a target with Rights for Vapors as an
Yeah,
advocacy entity. I can be sued, but they say something about resetting a clock from 15 years from the day of the legislation or 15 years from day of claim. And
yeah,
that just means that they can go 15 years back.
yeah. That's it. So there's normally in every province there's statute of limitations that apply. So a lot
Hmm.
of provinces like Ontario
Yeah.
have a limitation period. You can't go back more than 2 years. And so BC is saying, well, we're not going to be able to go back just 2 years to recover these lost healthcare costs. We're going to go back 15 years. And yes, you're right, Maria. I'm sorry to tell you, you could be it specifically mentions associations, industry
Mhm.
associations, and individuals who provide advice
Yeah.
to the industry. I mean, basically, practically, if you shake the hand of a vape shop owner, you can be sued. I mean, it's almost that bad.
And then the other thing is that I don't know what this means, but liability may be established in the aggregate through presumptions and applied retroactively. So we don't really have room to defend ourselves, do we, in some of this stuff?
Well, the point about that is that you do have room to defend yourself, but your defense is going to be limited basically to liability to prove that you didn't mislead consumers or do anything else wrong to consumers. But the way it's stacked against you is if the government of British Columbia says, well, we believe that we're out $200 million because of healthcare costs from vaping. All it takes is a certificate from the relevant minister submitted to the court saying this is how much we're out, $200 million. And the court has to accept that number. You can't go behind it according to this legislation, which is really outrageous. I mean, it's not the normal process at all. But what I want to caution people is that the Supreme Court in the Imperial Tobacco case said that even if the process is a little abnormal and a little stacked in favor of the government, it's not necessarily unjust as long as people have a chance to defend themselves. You will still have a chance to defend yourself to say, I didn't mislead anyone. I didn't, there's no harm caused by this. Uh, there's no evidence of a causal connection between my activities and the harm that you say happened to the healthcare system. That's where you'll be allowed to defend yourself. But where you will not be allowed to defend yourself is if you say, in fact, uh, it didn't cost you $200 million. I actually saved you $200 million because of all the people who didn't take up smoking. The court will not entertain that argument.
Okay. And the other thing is that every other government body can piggyback. BC can sue on behalf of Canada, BC can sue on behalf of Ontario.
Yep.
So they're pretty much saying, let's us take the reign.
Yeah. And that whole question about whether BC could meddle in what's going on in other provinces, that was also addressed by the Imperial Tobacco case. Um, because normally provinces only have jurisdiction in their own neighborhoods, right? BC
Mhm.
can't make laws for Ontario and vice versa. But in Imperial Tobacco, the Supreme Court of Canada said, well, as long as there's a real connection with British Columbia, and there is a real connection here because they, even if the tobacco was made in Montreal, it's sold in British Columbia, and people were harmed in British Columbia. That's good enough. So it's okay if there's some extraterritorial reach. So it's going to be difficult to challenge that part as well.
Okay. One of the questions is the TVPA, the Tobacco Vaping Products Act, prevents anyone in the vaping industry from making health claims. How can they justify this?
Yeah, I mean, to me, that is the nub of it, is you guys need to be prepared for that very first if the legislation goes through and it's not successfully constitutionally challenged, no doubt, there for the big issue, I think that where the main fight is going to occur is um, how were consumers misled or otherwise harmed in this situation? Because as long as the person who's being sued has complied with the relevant marketing rules, and we all know that marketing rules are onerous, um, it's hard to see how you have done something unlawful or improper. Like as long there's it in a regulated industry, if you follow all the rules, there you don't have to think about what other rules might apply to you or do something over and above what the rules say. So I think, I mean, it's obvious there are some bad actors in every industry. So I could see it happening to somebody who is disregarding the rules about representations. But for the vast majority of legitimate players in this business, I don't see how they're going to be able to establish that you've done something wrong. I just don't see it because you're highly regulated, and this idea that you're running around deceiving people, you know, we know that there was that Jewel did that, but that's Jewel and that's the USA. That's not
Yeah.
Canada, the average
I,
vaping organization here.
and I don't think that people realize that Juul was not in the Canadian market at that time. And I don't think any of these politicians actually understand vaping. I read through the Hanser report today, and people were talking about popcorn lung as the risk. So I'm not sure where they're going to find those popcorn lung cases. There is, there's lots of thank yous for you attending and giving us your time. We appreciate that. I don't know. So as a store owner selling BC compliant products, could they be at risk and sued? She's just a little bit. Could a vape shop own a shop that sells compliant products be at risk if the government chooses so?
Yes, so when I say at risk of being sued, I
Yeah.
don't think at risk of being successfully sued. But if you look, you know, at what's going on in the United States right now, for example, with all of these prosecutions that Donald Trump is launching against his enemies, you know, I think a lot of those people they're going to be acquitted. They're going to win their lawsuits. But in the meantime, their reputation is damaged because they're portrayed as criminals, and they have to spend a boatload of money defending themselves in court because of this bogus proceeding. And that's what I'm really concerned about for a small vape shop owner in BC. Like, I'm sure if she's complying with the legislation, that even after, if this bill passed exactly the way it is, that any lawsuit brought against her is going to fail, but they will be able to bring a lawsuit against her. And that's the problem. And when are you going to do that? What are you going to do?
Um, I couldn't agree more. It's the fear because when I read this and then I kind of started asking questions, and when I realized that, you know, this, as you said, this webinar, I have a history of educating people about vaping and all that. And as a former shop owner, since they can reset it 15 years, I'm at risk at that. Having a juice line, if you make your own juice, like, you know, if you produce your own house brand, all this stuff. Caitlin wrote here, I read about the bill, and apparently, from what she understood, they wouldn't have to specifically prove the harm. They only have to give a statistic.
Yes. Well, the statistics they can use statistics for damages, but they still have to prove a vaping harm. They have to show that there was some kind of misrepresentation or that there was some toxic substance put into the liquid or something. They have to show that if it was a consumer suing the person, that there would be what we lawyers call a duty of care owed, and that there was a breach of that duty of care. It's not just a tax on the vaping industry. They still have to go to court and they still have to prove something. But what they've done is allowed the use of they've eliminated any inquiry into the amount of damages. They can just file a certificate with the court and say, it's cost us $200 million, and the court has to accept that. And they've done some other things about statistics and so on to try and make it easier for them to win. But they haven't eliminated the obligation to prove that something that the target, whether it's a vape shop owner or Maria or me, they have to still show that we did something wrong that that led to harm to consumers. And that the reason they did that is not because they like you. Let's be clear about this. The reason they did that is because that was critical to the thinking of the Supreme Court of Canada in the Imperial Tobacco case, because the tobacco company said, this is illegal because they've tied our hands. We don't have a chance to defend ourselves. And the court said, yes, you do. Sure, they've stacked the deck a little, but you can still defend yourself, so it's constitutional. So British Columbia was careful not to take away your right to defend yourself altogether, because if they did, then they wouldn't be able to rely on the Imperial Tobacco case.
So they're using past precedent.
Yes. This, if you look at the bill that was an issue in Imperial Tobacco, it's almost identical to this bill. That's done very deliberately because precedent is how our legal system works. You go to a court challenge and they say, well, Madam Justice Smith, in British Columbia, the Supreme Court of Canada ruled on this very point in Imperial Tobacco, and you are bound to reach the same conclusion. You're not allowed to reach a different conclusion. That's how precedent works.
So even though it's a reduced risk product.
Yep.
Um, okay, this is a lot. Would you
Yeah, right.
say, just out of curiosity, would you say right now the way it's going, because the way the bill has been going through the legislative process, they're moving to a committee of the whole, which means no stakeholders feedback. It's really going to be debated. They're really pushing this very quickly through.
Yes, and apparently, like I don't live in British Columbia, but my information is that that's the style of this Attorney General, that she has a lot of clout and she is not really interested in debates about her bills. Once she decides what she thinks is right, she rams it through as quickly as possible. And that's what and so it's not just about this bill, that's just how she does business.
Okay. That's good to know about Nikki Sharma. Are there any other questions, guys, for Doug based on this bill? A lot of people are saying they already make a lot of money, like off of the taxing on this.
They do make a lot of money. And as I say, to me the whole thing is illogical, because in tobacco it made sense because it's clear that combustible tobacco costs British Columbia money, but the vaping business actually saves them money because people are not using tobacco. It reduces the burden on the healthcare system. Plus, they have all of this revenue from HST, et cetera, et cetera.
And the $1 billion.
Mhm.
Uh,
So so they've yeah, but so it is a money grab, but it's also, don't make no mistake about it. It's the, Physicians for a Smoke-Free Canada and all the usual suspects that are behind this, trying to shut down the vaping business altogether because they know what's good for you.
yes, absolutely. And I also am going to say this because I'm doing a lot of work with the World Health Organization and the framework control of tobacco control, whatever convention of tobacco control. I do believe that Canada is being beta tested for similar lawsuit to happen around the world. And I think we are being beta tested from the World Health Organization and the COP, the Conference of the Parties, where they're all meeting to talk about how to get rid of nicotine, is happening mid-November. So this is the timing is very perfect. And those usual players will be at that conference. It is scary. The other thing is, Doug, this was just a little conspiracy theory I came up with. The tobacco companies only need can only have to give back for the settlement 85 cents on every dollar they sell in cigarettes. The
Yeah.
rest of the money that they make is free to them to keep. It's not free, it's for them to keep. And they've been moving into nicotine pouches, vaping and stuff like that. Do you think this is um another way for governments to try and stick it to big tobacco?
Oh, sure. That's what I mean, they think you are big tobacco.
Oh
Let's
yeah,
be clear.
that's true.
Yeah, they think you are big tobacco. And so that's why they think that you've got deep pockets and they want to they've already reached deep into the right pocket. So now they want to reach into the left pocket. They did conclude in the Imperial Tobacco settlement, you're right, they concluded that they weren't going to put the tobacco companies out of business altogether, that it made more sense to just try and claw out almost all of the profits from the tobacco business rather than killing it altogether. But I'm not sure that the same result would obtain with vaping. We'd have to see. But I do think that there's significant arguments to be made that you're comparing apples and oranges. You know, the only thing that two products have in common is that they contain, well, not all vaping liquid contains nicotine, but a lot of
In
it does.
BC, it does. It's illegal to sell nicotine-free stuff in BC.
Oh, there you are. So the point is that uh, it's not, you know, there's lots of things that have nicotine in them that are sold to try and help people stop smoking, right? And still deliver nicotine. And if they wanted to outlaw nicotine, they couldn't because that would be an intrusion on the federal law power.
Okay. Well, Doug, I want to say thank you. I think I'm going to you've given us quite a bit of your time today when you're not feeling well as well. Thank you so much. And I think if anyone else has questions, you can direct them to the CVA at Ashley maybe can write the CVA email address down there. And, if anybody wants to stay after and talk about initiatives and what we're thinking of doing, with what's going on right now, how to advocate on your own, like how to reach out to your MLA, how to reach out to the Attorney General. Since she's wants to act on behalf of all Canadians, I feel that she should be able to receive emails from all Canadians.
Yeah, fair point.
Yeah. Thank you so much, Doug, and take care.
Thank you. I hope I'm feeling better soon. Maybe I'll get some of that Vicks inhaler and inhale that great Vicks steam that
Yes.
so much
Oh,
when I was a kid.
Vicks cures everything.
Okay, thanks a lot, everybody.
Thank you. Guys, I'm going to pull up some people. Oh, there we go. Ashley put that. If anybody wants to just put up your hand if you want to chat, if you can put up your hand on this thing.